Over 5 years after electoral bonds entered Indian democracy, the Supreme Court has finally started hearing a batch of petitions challenging the scheme for funding political parties. So, for this video, let me take you through a quick refresher on what these bonds are, how they are introduced, and why these bonds are before the Supreme Court now. Now, the scheme was notified by the government in January 2018. Simply speaking, electoral bonds are an instrument through which anyone can donate money to political parties. These bonds are sold in multiples of rupees 1,000, 10,000, 1 lakh, 10 lakh, and rupees 1 crore. And these bonds can be purchased by any Indian citizen or by entities incorporated or established in India. How can they buy it? These bonds can be bought from authorized branches of the State Bank of India, and the donor is required to pay the amount, say rupees 10 lakhs, through a check or digital mechanism, so no cash. And they have to pay this to the authorized SBI branch. The donor can then give this bond to the party or parties of their choice. The political parties can choose to encash such bonds within 15 days of receiving them and fund their electoral expenses. And the entire process ensures that these bonds are completely anonymous. The bond does not carry the name of the buyer or the payee. So we won't know where these funds to parties are coming from. Also, according to the scheme, only eligible political parties with 1% vote share can get funds through electoral bonds. Legally, just a little bit on how these bonds were introduced. They were introduced by the Finance Act 2017, which amended various provisions of various laws. You can see a few of these laws on your screens right now. And how they did this, for instance, the Representation of People's Act amendment exempts political parties from the requirement to record donations received through electoral bonds in their contribution reports to the Election Commission. The amendments to the FCRA allow foreign companies owning majority stakes in Indian companies to donate to political parties. Similarly, the income tax amendments allow anonymous donations up to rupees 20,000 and exempts donors from providing their names or PAN details. So the essence of the scheme is that political parties are not required to maintain any record of the donations or the names and addresses of the donors of these bonds. The scheme ensured that the identity of the donor is completely confidential and airtight. In fact, the scheme says that the authorized bank will not disclose any information about the purchaser of the bonds to any authority for any purpose. Of course, the scheme was challenged right away before the Supreme Court. Several petitions, including those by CPI, Marxist, and two NGOs, which are Association for Democratic Reforms, ADR, and Common Cause, they were filed before the Supreme Court to challenge the scheme. And they have raised several concerns on the scheme. For starters, the petition filed by the NGOs takes objection to the opacity in political funding introduced by the electoral bonds. It contends that the electoral bonds are designed to keep the identity of donors secret from company auditors, income tax authorities, election commission, and finally from the public at large, who are the voters. This it contends is against public policy as it leads to opacity and permits foreign influence in government policies. On similar lines, other petitions contend that the amendments jeopardize the very foundation of Indian democracy, submitting that the, and I quote, confluence of uncapped corporate resources funding political parties can only lead to private corporate interests taking precedence over the needs and rights of the people in the state in policy considerations, unquote. It claims that the amendments are contrary to the recommendations of the Election Commission and Law Commission of India. Additionally, the petitions also question the passing of the Finance Act as a money bill by passing the Rajya Sabha. So, just briefly, a money bill originates in the Lok Sabha, and once passed by a simple majority, it is sent to the Rajya Sabha for its recommendations. But these recommendations are not binding. And how has the central government responded to these petitions so far in the Supreme Court? In fact, it actually took 4 dates and 17 months since September 2017, which was when one of the first petitions was filed. It took that long for the Supreme Court to actually receive a response from both the Centre and the Election Commission of India, a response to these petitions challenging electoral bonds. The central government submitted 2 affidavits in March and April 2019 in support of the scheme, which it asserted was meant to eradicate black money and enhance accountability. The centre submitted that the identity of a buyer was kept anonymous to maintain his or her privacy. It also denied allegations that the amendments and subsequent notifications seek to create an anonymous and secretive mechanism for increasing the wealth of political parties or bring in unreasonable restrictions on the freedom of information regarding identities of the contributors. So it denied all these allegations. However, surprisingly, the ECI in its affidavit to the court in March 2019 raised apprehensions over the scheme. It said that the scheme allowed unlimited corporate funding, which would have a serious impact on transparency in funding of political parties. The poll panel, in fact, argued that it was not against the scheme as such, but opposed the anonymity attached to it from its inception. It claimed that electoral bonds made the Commission's job of tracking donations from overseas and government companies, both legally barred at present, rather difficult. Now, in April 2019, the Supreme Court issued an interim order directing all political parties to submit the details of all bonds received until 15th May 2019 to the Election Commission by 30th May 2019. And in its order, the court noted that the contentions before it, and I quote again, give rise to weighty issues which have a tremendous bearing on the sanctity of the electoral process in the country, unquote, and that these issues would require an in-depth hearing. But that in-depth hearing didn't happen until now. Meanwhile, the court had at that time refused to stay the scheme as well and directed that the details be submitted to the Election Commission in a sealed cover. On 16th October this year, the Supreme Court finally referred the case to a constitution bench, and this bench is the one, this 5-judge bench, is finally hearing the case now. That's all I have for you for today. This is Apurva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.